Welcome to episode 2, Truck Case Mentor. I'm Fred Berkey, and we're discussing crafting legal theories that win in today's episode. Let's jump in.
One of the 10 things needed to be successful in a truck case is crafting legal theories that win. A truck case is never just about whether the driver caused the collision. It's about whether the motor carrier operated its business safely. The motor carrier has a responsibility to qualify drivers, train drivers, supervise drivers, and to otherwise make certain that the system that they've created has management and controls in place to make certain that the whole system operates safely. For example, a motor carrier is required to qualify its drivers. They have to do things like conduct a pre-employment drug screen. They have to check with former employers to make certain that the driver that they're going to hire has a safety record and hasn't had accidents that have been preventable or that indicate a serious problem with the driver, such as a high-risk driver, someone who's prone to speeding, for example, or creating crashes that could have been preventable. The motor carrier is also going to be responsible to train their drivers to make certain that they comply with federal motor carrier safety regulations, as well as their own internal driving policies and procedures. One of the most important things a motor carrier is responsible to do is to ensure compliance with hours of service requirements imposed by the federal motor carrier safety regulations, as well as the record of duty status or driver logs that the truck driver is required to prepare at every shift. The motor carrier is also responsible to maintain their equipment so that crashes don't occur from things like overweight, failed brakes, or other equipment failure. When you get into a lawsuit, it's not uncommon to get into 36,000, 50,000 perhaps documents, multiple legal theories, and so this can just create mass confusion. So the process of finding a place of focus for your legal arguments is absolutely critical. Deciding what's important and what to emphasize is the key to crafting a legal argument that wins. In a truck case, what's most important is the motor carrier safety failures. Some years ago, I represented a family whose mother had been transported in a Medicaid transport. She was thrown from her wheelchair because she hadn't been secured by the driver. She was treated at the local hospital and was there for 3 months in ICU before she ultimately died. In that case, there were multiple entities. The transport was operated by an independent contractor who had been dispatched by a second company who operated as a broker. This created confusion, potentially, because the broker assumed no responsibility for the crash, insisting that the transport was an independent contractor. And as you know, that's a typical and common defense. An independent contractor would not provide any liability for another party unless there was some sort of master-servant relationship or where there's control of time, manner, and method of, in this case, delivery. I realized the only way to hopefully make an adequate compensation for the family was to not only capture the transport, but to also find liability against the broker. And that was a real tough problem. I spent a great deal of time exploring different legal theories, thinking out of the box. It really involved a lot of creative thought and intention in finding a legal theory that would explain some key things I knew a jury would ask, which is not only what happened, that it's pretty obvious in that case. The what was the fact that the van driver didn't adequately secure my client to her wheelchair, and as a result, she was thrown free when the van stopped suddenly. More importantly, and something that you always want to find in any case that you're working on involving a truck, is why did the thing happen? So in this case, I worked really hard to identify the why. The process you should take in any truck case is to identify first all the rules, regulations, statutes, and best practices in the industry that would provide the standard of care that the motor carrier is required to follow. It's this process of understanding the why through the different responsibilities that are imposed on the motor carrier that leads you to answering the question. And to illustrate it, in this case, I knew that training was going to be a key issue because the broker was responsible to train their transport providers. And yet, beside the introductory course that they offered, no real training was offered to the van driver who had immediate contact with the passenger, in this case, my client, on how to adequately secure a wheelchair. The broker simply took the position that they were not responsible to train the van drivers because they were independent contractors. However, the broker neglected to train the companies that employed the van drivers on how to install safety systems. And that was a key requirement imposed as a responsibility by well-known sources such as the National Highway Transportation and Safety Administration. So the broker insisted that the van operator was independent and had no responsibility. So they moved away from that at every opportunity. And yet, with the right theory that I installed, the harder the broker moved away from responsibility for the van operators, the stronger our argument became. So the case boiled down to some key questions that I knew a jury would need to have answered. One, what happened? In that case, the van driver didn't adequately secure the passenger, my client, to her wheelchair, and as a result, she was thrown free and died. And two, but most importantly, why did it happen? In this case, it happened because the broker refused to take responsibility to train van operators to install safety systems where their drivers would know to securely fasten wheelchair passengers into their wheelchairs. And then another question you should always answer for your jury is why? Why should we care? Why should the jury care? In this case, everybody has the experience of having grandparents or perhaps elderly parents who need to get to their doctor appointments. And in many cases, they're going to be transported, oftentimes in a weakened state. So the thought that that experience could happen to them made it immediate to them and therefore motivated them to act. Turning the focus on a key vulnerability in that case yielded settlement and mediation for nearly $5 million. So let's break it down and let me give you some highlights you can take back to your desk. 1, work creatively to find out-of-the-box legal theories. 2, answer the critical questions a jury is always going to ask. Not only what happened, but why did it happen, and why should we care? 3, find the bear trap. That's the vulnerability the defense will move at any cost to get away from. 4, if not, start over and work again until you find it. 5, once you do find it, work hard and make that the sole focus of your case. 6, every deposition and argument to your judge should lead to that sole focus. When exploring legal theories and deciding what argument will have the most persuasive impact, I'm first looking at, does it make sense? Is it going to make sense to a jury? Does it track the duties that are required by statutes, rules, and regulations? Does it explain the why? Does it explain why it happened to a jury? And it has to make sense to them. In other words, it has to be logical, and it has to answer also the question of why should we care about it? That could lead to perhaps several different competing legal theories. In the case I provided the illustration, I think before I settled on the one, I went back and forth to the drawing board and perhaps had something like 5 different theories. I would then fine-tune the legal arguments with focus groups, because the goal there is to identify the arguments that a jury is going to resonate with. When deciding on whether to abandon a legal theory, I think it's probably going to be mainly focused on causation. So if you can't tie the legal theory logically to the crash as a direct contributing factor, obviously that's going to be a stopping point and you'll have to start over. Thanks for joining. If you have any further questions, don't hesitate to reach out to Fred at truckcasementor.com.